In the pro se court, all cases are first referred to mediation before going to trial. Mediation is a chance for you and the other side to meet together with a mediator to see if you can reach an agreement. When the judge sends your case to mediation, you and the other side will work with a mediator. A mediator is a neutral person, meaning they are not on anyone's side and work for the court. A mediator has no stake in who wins the case. Mediators have received special training to help people talk through disputes and come up with solutions. The mediator's role is not to evaluate your case, tell you what might happen in court, or to give you legal advice. The mediator will not force you to agree to a settlement. You decide whether an agreement is reached, and it will be settled. The mediator's role is to ask both sides tough questions to get each side to think about what is in their best interests and to weigh the benefits and risk of going to trial. The mediator will make sure that each side is heard during mediation. The mediator will also guide both sides to a resolution that meets their interest, whatever that may be, even if that means going back before the judge because an agreement cannot be reached. Mediation is confidential, which means that what is said during mediation cannot be shared with anyone else. The mediator will not testify on either side's behalf or talk to anyone, like the judge or clerks, about what happens during mediation. If you cannot agree, the mediator will return your case's file to the judge's clerk, and you will go before the judge as if the mediation never happened. Then, it will be up to the judge whether or not your case is heard that same day or on another day. If you have a trial, the judge decides the outcome of your case. Generally, once an agreement is reached, the mediator will return your case's file to the judge's clerk with a copy of your agreement. In some courtrooms, you are free to go. In others, the judge or clerk will instruct you if there are any other court papers that you will need to fill out. Every courtroom is different, so if you are unsure of what to do, just ask. Your time with a mediator may be limited because there are other cases in court that day. To best use your time, it is a good idea to think about ways you would be willing to settle your case with the other side. In mediation, anything goes, so you have a lot more options than you would if the judge decided your case. If you have a trial, the judge decides the outcome of your case. You may not like the judge's decision. However, in mediation, both sides have a say in how things are settled. Also, in mediation, you have more options for how to solve your dispute that may not be available if your case goes to trial. Mediation is also a time for you to consider your position and possibly go before the judge more prepared. We hope this video helped you better understand the pro se court at the Daley Center in Cook County, Illinois. More information about going to court can be found on this website.